Can work permits for immigrants be revoked in the U.S.? Have you ever wondered if work permits for immigrants can be taken away in the United States? This is an important question for many who are navigating their careers in a new country. Let's break down the facts surrounding this topic. Yes, work permits, which are officially called employment authorization documents, can indeed be revoked under certain conditions. The United States Citizenship and Immigration Services has the power to revoke an approved work permit if specific criteria are met. One key reason for revocation is fraud or misrepresentation. If the application for the work permit contains false information, the approval may be revoked. It's essential to ensure that all details provided are accurate and truthful. Another reason could be a change in eligibility. If an immigrant no longer meets the requirements for the work permit category under which it was granted, it can be revoked. This means staying informed about the criteria is crucial. Additionally, if the work permit is based on an employer petition, the employer has the right to withdraw that petition. This can lead to the revocation of the work permit, so maintaining good communication with employers is important. Security or law enforcement concerns can also trigger revocation. If a law enforcement agency informs the United States Citizenship and Immigration Services of issues such as non-cooperation with investigations, this could lead to revocation. For certain humanitarian or parole-based work permits, if the terms of the program are violated or terminated, the related work authorization can be revoked. It is vital to adhere to the guidelines set forth in these programs. When the United States Citizenship and Immigration Services intends to revoke a work permit, they usually issue a notice of intent to revoke. This notice gives the individual a chance to respond. However, in some situations, revocation can happen automatically, such as when a beneficiary informs the United States Citizenship and Immigration Services that they will not apply for admission to the United States. For employers, if an employee's work permit is revoked, they must re-verify the employee's work authorization using Form I-9. Supplement B. Employers cannot continue to employ someone whose work permit has been revoked, even if the physical card appears valid and unexpired. For immigrants seeking to maintain their job search and career development, it is essential to understand that work permits are not permanent. Keeping all application information accurate and up to date can help avoid issues. Responding promptly to any notices from the United States Citizenship and Immigration Services regarding revocation is also important. Additionally, maintaining open communication with employers about work authorization status can prevent misunderstandings. If a notice of revocation is received, seeking legal advice can help protect employment rights and immigration status. Being aware of these facts helps immigrants navigate the complexities of maintaining work authorization in the United States. This knowledge supports their ability to sustain employment and grow their careers while complying with immigration laws.